My name is TJ Teed, and welcome back to Courtney's Voice for Justice. There are moments when a case reaches a turning point. Today happens to be one of those moments. Last week, we formally announced we were taking action under 42 U.S.C. 1983. Today, we're formally adding 42 U.S.C. 1985 and 42 U.S.C. 1986 to our federal civil rights lawsuit. These statutes exist for a reason. Section 1985 addresses conspiracies, when two or more individuals coordinate to interfere with constitutional rights, obstruct justice, intimidate parties or witnesses, or deny equal protection under the law. Section 1986 applies when individuals knew such a conspiracy was occurring and had the power to prevent it and failed to act. This amendment reflects what the evidence shows, that the harm in this case was not the result of a single mistake or an isolated decision, but of coordinated conduct, shared knowledge, and deliberate inaction. And this part matters. There is a persistent belief, particularly within the juvenile court system, that because proceedings are labeled confidential, protective, or even in the best interest of the child, that rules are different. They are not. Juvenile courts are not exempt from the U.S. Constitution. State actors and juvenile proceedings are not immune from federal civil rights law. Discretion does not replace due process. Federal law still applies. During questioning at our last hearing regarding this case, the guardian ad litem looked at my wife and said that she knows the law. Well, I beg to differ. Because if federal civil rights law had been properly understood and applied, we would not be filing these claims today. Knowing the law is not about saying the words, it is about recognizing when constitutional boundaries apply and respecting them, even in juvenile court. Federal civil rights statutes apply to guardian ad litems. They apply to attorneys. They apply to juvenile proceedings. And they apply regardless of how much discretion a state court believes it has. This filing is not about disagreement with outcomes. It is not about emotion, and it's not about attacking a system for existing. It is about holding that system to the same federal standards that bind every other court in this country. When someone seeks judicial office, the public has a right to expect constitutional literacy, respect for federal supremacy, and an understanding that no courtroom operates above the law. That is not politics. That is not personal. That is public trust. By adding 42 U.S.C. 1985 and 1986, we are ensuring that conspiracy, knowledge, and failure to intervene are examined where the law requires they be examined, in federal court. We will proceed carefully, and we will proceed lawfully, and we'll proceed without silence. Because civil rights are not optional, because juvenile court is not an exception, and because no family loses their constitutional protections behind closed doors. This is why Courtney's Voice of Justice exists.